Hi, my name is Sarah Sheikh, and we are now going to be talking about the declaration portion of the restraining order, which is one of the most important parts of a restraining order petition. A good declaration can get a petitioner their restraining order. A bad declaration could prevent them from getting a restraining order. So this is what I would say is the meat of the restraining order, and it is something that you should be spending some time on and something you should be really carefully working on before we send the litigant on their way. So in order to get to the declaration portion of the program, you have to go back to the original link, which is the Dash website, the Dash Hot Talks website. Now, at this point, you will have already gone through the forms section, and you would have hit finished and you would have saved and gotten the PDF of the document. And then from there, you would then click on the second link, which is the Domestic Violence Petitioners Declaration. And once you clicked on that, the program would, well, I have to show you how to sign in, but we've signed out, and basically you want to go in and then click on the link, and from there, in this section right here, as you've already seen this, it's you already signed up, log in, and at this point I am going to sign in with the same username and password that I used for the first section, because if you go into a different account, then you wouldn't have the same details that you've already done. In this case, the very first file is going to be the most recent thing that you've saved in this account, so we're going to click on that. And in this part of the program, of the process of helping someone get a restraining order, you don't actually work in the Hot Talks program. You would hit finish immediately. So on the bottom right, you have that finish button, which I hit immediately, and then the program is processing it. And in this section where we are not going to save. We should not be saving, because if we save right now, we're going to lose everything we put down in the declaration section in those fields that we had. We're going to click on the right here where it says get your document. And then from there, we're going to click on get document. And so what that does is it opens up the it opens up the declaration for you. And remember I said that it opens up a Microsoft Word document. And what you do is you have to work with it. So the program has already put in the details. If you had skipped the section in the first link, then this would largely be blank. It pre-fills out the need for a Spanish interpreter. It also pre-fills out for you an introduction, which tells the court what the relationship is. Now, one of the things the program does is if you click the box that says we are dating or used to date, because it covers both options, in the declaration paragraph, it'll literally say we are dating, in parentheses, or used to date. So you do have to pick the one that applies. We have the details of the social worker that are in here, because the program, we did say yes, a social worker had referred the litigant to get a restraining order. But if you hadn't put any details in of the abuse, none of this would have been in there. We have the gun information right here. We have the child custody request and reasons for why the litigant should get what they're asking for. We have the abduction prevention over here. And then we have other orders that we're asking for. For example, right here, I would like property control of the black Toyota Camry, because notice how there's nothing there, because the program didn't give us a chance to fill that in. But we do have to remember to fill that information in for the litigant at this point. We have the family pet. We then also have a section that says, I ask the court to order RP to pay the following expenses. This is the reimbursement section caused by the abuse, but then there's nothing there. So the program didn't fill this part in either. So that's something we would help the litigant fill in as well. And then finally, the one thing that's also missing is the conclusion. So this is what we have, what the program gives us as a Microsoft Word document. Notice how we have like gaps right here. There's like extra margins, how we have gaps here in between. And basically, you're going to work with this and you're going to condense it, add more in terms of maybe the font. You're going to get rid of the margins, the gaps. You're going to put in more details of abuse. Most likely you will also be putting in a summary paragraph because our court wants a summary of what the abuse has been. And then conclusion. I would never want you to just immediately print something out like this and bring it for back or for review from the attorney, because we expect you to work on the declaration and give it a professional appearance before it comes to us. Because remember, appearances matter, and a judge is going to be reading this, and we want the litigant to put their best foot forward. Now, a declaration, and we have some samples we can also email you. A declaration is basically a summary. It's a statement of facts, also summary of course, but statement of facts that petitioner signs under penalty of perjury. We start off by focusing on the most recent, and then the second most recent, but we still do that summary so the court knows its entire history of abuse. And you will have litigants when they sit down with you where they're throwing everything at you. Well, litigants will be throwing everything at you, and so what you do is you have to take that information, focus on what's important, and experience will teach you what is important, and then condense that into one statement that they can then sign off on. Now, going back to our PowerPoint, so we get into the declaration portion, and basically, like I said, the program will give you the relationship between the parties. It'll give you the most recent abuse if you entered it in there. And if it's more than 2 weeks ago, you do have to be a bit more detailed in terms of why it took the litigant so long to come in and get this restraining order. If it's something merely like I was too injured to come in, I had to flee the state because of the abuse, I couldn't take time off of work, I didn't know that there was something available like this. Any of those reasons are fine. It's not for us to judge. We would just put that information in the declaration, and it would be up to the judge to decide if it was sufficient reason for the wait. We then detail the second most recent incident of abuse, and it says and or, that in the sense that if there is no second recent incident. But there should always be a history of abuse about what this other party has been doing to our petitioner in terms of verbal and physical and emotional or financial control. Whatever might be going on, we want to throw all of those details in there. And of course, we will need to address any other orders requested. In the declaration that we got, there was, like I showed you, there was custody orders and an explanation for why the petitioner should get those custody orders. We had debt payments in there. We had reimbursement for damages. We had guns, things like that. That information was all in there for the judge as well. The only thing that was, another thing that was missing was the conclusion. So there should be a conclusion where you're telling the court what you want. Well, the petitioner is telling the court what the petitioner wants. For example, due to RP's abuse, I'm afraid for my safety and the safety of my children. Therefore, I respectfully request this restraining order. So you're concluding it for the court that, Your Honor, I'm telling you all these details, and what I want is I want a restraining order protecting us from this individual. When you're helping the litigant write these incidents down, the summary down, you have to be very detailed, at least on the two most recent incidents, where we have to throw in their bad words used, threats made, what were the actions taken, what were the injuries caused by the abuse. Quotations, use actual quotations, and even if there's profanity, we have to actually spell it out. A litigant might be very uncomfortable telling us what the other party said. They would be like, does the judge really want to know? Can I say that to a judge? And it's like, yes, you have to provide that information because that's very important to the court. You don't want to make a conclusion for the judge saying he used bad words and he was being abusive. You want to give the court the details, and it's up to the judge to say, yes, that is abuse. Yes, those are bad words. And that's, with actual quotations, that is how a judge would know. Anything the litigant tells you, you have to be aware that there can't be any kind of secondhand knowledge. So they can't say, my neighbors, daughters, whoever told me that RP did this. It has to be whatever the petitioner saw on their own. And when you're describing everything specifically, you're putting the details in there, we don't expect you to be creative. in the sense that you don't have to be creative with the structure or the format of the declaration. We just want you to be creative with your questioning so we can get the important details. Sometimes you'll have litigants who can't really state what makes them afraid until you find other ways, until you press and you get more details where the actual abuse might come out. Any question to ask when someone's telling you something is, when you're putting it down, when you're writing it down in the statement, is, does it really matter? Because in the sense, does it justify restraining the other person? So whatever conduct you're describing, would the court think that it was enough to justify a restraining order against this person? And one thing that judges don't like is they don't like words like always, often, continuously, constantly, because judges also always feel that it would be physically impossible for someone to be continuously or constantly doing something, because that would be a 24/7 kind of idea. So we want to use numbers rather than saying continuously, constantly, because that gives the court an idea that yes, it was happening a lot, but it wouldn't irritate the judge in terms of, because there won't be any over-exaggeration. Now, for harassment and stalking, because we don't have huge incidents of physical abuse, very detailed incident of an actual threat of violence, we have, I saw him outside my house. We have, he called me. We have to get into the numbers. So the number of calls made on a daily basis, is there a phone record or a phone log that the litigant could get and bring with them to the hearing? Number of text messages sent, and what was the content of these? We can do like a summary of that, put actual quotations of the really serious stuff, number of voicemails left, and what was the content of those voicemails, and the stalking. Well, how many times? Where did you see them? How long were they there? So details like that. We get into the really detailed aspect of that. And what you want to remember is that you want the court to make the conclusion that there is harassment and stalking going on, and a lot of it going on, but you have to provide the basis for the court to make that conclusion. It's going to be, the emphasis is going to be on what did the other party do to make you afraid. If you ask any more specific questions than that, then you're suggesting answers, and we don't want that either. It is up to you to listen carefully, but you have to, as volunteers, direct the interview. As I was stating beforehand, it becomes very difficult when we have litigants who might be sitting with someone for the first time who's listening to them and willing to listen to them. And it's difficult to control them, but we need to do that so that we can get them out of there and filing their restraining order. Because remember I said that the DASH clinic is only open in the mornings. Initially, when we're starting out as a volunteer, it might take you 3 hours to do one restraining order. So we don't want an over-talkative litigant preventing themselves from being unable to file a restraining order that day. So direct the interview, get the answers you need, and write them down so that the court will have the information they need to make that decision. Really quickly, we're going to go to a sample that I would want you to look at to see the difference between what a good sample is and what a bad sample is for a harassment/stalking situation. This is an example of a harassment and stalking situation where a litigant might be overbroad in terms of giving you the details you need to do a declaration, and these details are nowhere near enough what we need for a harassment and stalking situation. So in this situation, we have RP has been harassing and stalking me for the past 5 months. He constantly calls me. When I pick up, he shouts at me and calls me names. RP also text messages me all the time. He has threatened me in these text messages, making me feel that I am in danger. I have told him to stop contacting me, but he will not listen. He also follows me all the time and shows up everywhere I go. I have told him to stay away from me, but he only laughs. So as you can see, it's very general, very broad. We do not have any specific quotations of what kind of names he calls her, how he threatens her, where has she seen him, how often has she seen him, how often does he call and text her. So we don't have any of those details, and we're using the one that the court would be really unhappy with. So let's go down to the next example. And this is just a more specific details of the same of the same scenario. So in this one we have, he's been harassing and stalking her for the past 5 months. He calls her at least 10 times a day. Sometimes he calls her as much as 20 times a day. So we have a range for the judge. When she doesn't pick up, he leaves voicemails. And in these voicemails, he calls her names like bitch and slut and whore. He also text messages me about, it just says her about 50 times a day, sometimes texting her 5 times in 1 minute. There he also calls her names like effing bitch, and he says things like, stay away from him. If you don't, I'll make you sorry. I have lots of friends and they know what you have done to me. So we have threats like that. We have actual quotations. She knows about his past history of being friends with gang members, and she's explaining to the judge why she believes that's a valid threat is because of these friends, these gang member friends that he has. She also describes where she's seen him. She's seen him 5 times a week around her work and her home and her neighborhood grocery store, parked down the street. So basically, you can see how much of a level of detail we would need when it's just a purely, and I say just, but when it's purely a harassment and stalking situation where it becomes much more, it becomes much more difficult to describe the abuse because of the fact that we have so many details, and one incident might not be enough, and we have to find a way to wrap all of these into one paragraph. I mean, put them all into one paragraph and give them to the judge to make that determination that yes, there is abuse. So that's what a harassment situation should look like. You would have a lot of numbers. You'd probably have multiple text messages. And it would be a little bit different from physical abuse because at least with physical abuse, you have the actions taken, you have the injury, so you have something really concrete to point to in terms of describing the abuse. So remember, when you are working with this litigant, you are not writing exactly what they tell you because that would be very difficult and there would be a lot of extraneous detail in there. You're interviewing them and pulling out all the relevant information. The who, what, when, how. The why would never be important. And you have to finish up the narrative. Sometimes volunteers have a tendency to say, this happened and I called the police. And then the question then becomes is then what? Did the police come? Did they arrest him? Did they grant her an EPO? So then what? If the backup attorney is left asking that, or if you're left asking that when you're reading the declaration, you want to go back in and finish and round out the narrative with what happened, how did it conclude? So the petitioner's declaration needs to be, so once you get it from the Hot Docs program, you're going to polish it up before you submit it to the backup attorney. And it is okay to move stuff around. I ask you guys that you do that. Get rid of the margins, get rid of the gaps, make it look pretty. Make sure to finish the sentences that the program has left incomplete. And remember that the point of this is to give the judge a coherent story. So don't allow the litigant to direct the flow of the statement. It should focus on the important stuff. It should focus on the details, and everything else they can take care of at the hearing. Let's go over some examples. These are examples of different things that might be said in a declaration, and we're going to go over whether they're good or bad. So I will state them. I'll give you about 2 seconds to say if it's good or bad, and then we'll discuss why it would be good or bad. So came home intoxicated. It's bad, and that's because the litigant is making a conclusion for the judge. We want to describe the RP and what their behavior was like and how they smelled and what their movements were like, and we want the court to conclude that he was intoxicated. Verbally assaulted. Bad. It doesn't give the court an idea of what was said or what they did. It makes a conclusion once more. I called the police and he was arrested. Good. In this case, we're concluding the narrative for the court. The judge knows what happened at the end of this situation and how it concluded. I'm afraid for my safety and the safety of our children. Good. We're giving the court we're concluding the declaration for the court and saying this is what is happening. Of course, it needs to go on and ask the court for the request. It needs to request a restraining order, but it's a good start to the conclusion. Had him arrested. In this case, it's incomplete. I wouldn't say it's good. I wouldn't say it's bad, but we need to add on more to make it a good example. Broke my arm because. Bad. Do we care about the why? We do not care about the why. The important thing is that he broke her arm. Violent drunk. Bad. Once again, this is because we're making a conclusion. We want the court to make that conclusion. Passes domestic violence program. Okay, incomplete. Basically, it's maybe one of the other orders related probably to one of the other orders that the litigant might be asking for that I do not want, maybe visitation, so he passes the domestic violence program. As it is incomplete. I could tell he was intoxicated because he was stumbling in the house and slurring his words. Good. Very good. So we're giving the court details, and it's up to the court to say that yes, he was drunk. Hitting me on my face and body. Good. We're getting details of what he did and where he was injuring her. He yelled, "Get the F off the phone, bitch." Very good. We have an actual quotation. RP is responsible for domestic abuse and child abuse. Bad. Once again, we have a conclusion, and we want the court to make that conclusion. There has been verbal abuse. Once again, bad. Because this is the conclusion, we want the court to make that conclusion. We give the details. It's up to the judge to say, yes, there has been verbal abuse. Petitioner found RP. Very bad. Because remember, our declarations have to be from the point of view of the petitioner, so it should really say, I saw RP. No need to be in third person and no need to be this formal with it. I would like to ask for RP to move out. Incomplete. So yes, we're addressing an extra order she wants, but she or he wants, but we want to move on to why we should get what right she has to the property. I heard my arm break when I fell on the table. I would say good. It's a very good visual for the court that 1, she fell on the table, 2, her arm broke, and she went through the trauma of hearing her arm break. RP is an alcoholic and unfit father. Bad. Once again, it's a conclusion. Not here legally. Bad. The court does not care about either party's immigration status, so we should not be bringing that up. Joe witnessed RP hit me. Good. This tells the court that there were witnesses there, and hopefully she can bring this person with her to the hearing as a witness. $220. Bad. 1, because the dollar sign should be before the 220, but also because for what? What is she asking this amount for, and why should she get it? Last night. Bad. Spelling. So please, please, please watch out for grammatical and spelling errors. You need to proofread before you send it in for review, and always, always, always have the litigant read the declaration. Or if they're not English speaking, translate word for word what you wrote down. Because this is what the litigant is signing under penalty of perjury, and they are the ones that will take responsibility for the declaration. And it has to be, everything has to be what they say is the truth, and if there's any deviation from that, they will come back and they will be horrified, they will be afraid, and we've helped them do a declaration that's not something that represents what happened, and it's going to hurt their credibility as well. So while you're waiting for review, have the litigant go over the paperwork. Have the litigant go over the declaration and have them make sure that everything in there is what happened. I had a litigant come back who was literally in tears because in her declaration it said that the RP had raped her. But she was insistent that there was no rape. She did not want the use of that word in her declaration. And so we have to be very careful about things like that. So if they can read the declaration, have them read it. If they can't, translate word for word back to them so they know what's in that paperwork. Because they take the ultimate responsibility for those words. Once again, if you have any questions, you can email me. One thing to remember when you're doing a declaration is you have to be concise. There is a page limit. Our judges want these declarations to be 2 pages long maximum. If you go over by maybe half a page or maybe a paragraph, that's fine. But if you're getting longer than that, they will find it very hard to, they would be very, very unhappy in continuing on with reading that. So be concise, be focused, focus on the incidents of abuse, the recent ones, and a summary of what's been going on. And of course, work on the formatting, pay attention to grammar and spelling. If you do have any questions, you can contact me by email or talk to your on-site attorney. And this is the end of part 5 and the declaration writing portion of the training. There is one more part where we will go over a couple of scenarios and discuss different things you should be looking for in an interview. So please go on to part 6.